You've probably heard of robo-debt, the system that wrongly calculated welfare debts and affected thousands of Australians. But there was another method used for decades that also led to incorrect debts, and most people have never heard of it. It's called income apportionment.
It happened between 2003 and December 2020, so we think it's possibly in the 2 million people may have had an income-affected debt. There are going to be people possibly getting letters from Centrelink about debts that they may not have recalled they had because they have been on pause for quite a number of years.
Welcome to Law for Community Workers. In this episode, we're talking all about social security law. Yolanda from the Community Legal Education team chats to Dom, a social security lawyer, about 3 key changes to Centrelink debts, including the validation of income apportionment, the establishment of the income apportionment resolution scheme, and the new criteria for waiving debts to support people in vulnerable situations. If you're a community worker assisting someone with a Centrelink debt, make sure to keep listening to find out the legal options and what you can do to provide the best support. This interview was recorded on Wanneroo land and Gadigal land. We pay our respects to elders past and present. As we share in legal learning, may we acknowledge Aboriginal and Torres Strait Islander people as the first educators, storytellers, and lawmakers on the lands you're listening from.
A few months ago, there was some pretty significant changes to social security laws, especially around how Centrelink calculates debts and looks at how they're going to pursue them. We've got Dom Brown from Legal Aid with us today. Dom, can you tell us a bit about your background and your role at Legal Aid?
Hi, yes, I'm very excited to be here. I work in the social security team at Legal Aid.
Okay, so what does your team do, Dom?
Our team helps people who are having issues with Centrelink. So they might have an issue about not receiving a payment, being told they're not eligible, or being on the wrong rate of payment, possibly even having a debt that they owe to Centrelink. And we can help them raise that issue directly with Centrelink and ask Centrelink to look at that decision. Or if that doesn't work and they want to go to a tribunal to have someone else look at Centrelink's decision and see if it's right, we can help and represent them there.
Okay, and so you've just come back from Adelaide. What were you doing down there?
I was in the High Court in Adelaide, which was a very exciting moment for social security. Legal Aid was a submitting party in a really big social security case with Victorian Legal Aid, who are representing the applicant, who's the person who brought the case. And that case was about this really big issue that we call income apportionment. And essentially, there was an issue for a number of years about how Centrelink used people's income information, which is like money they might have earned from working or got from other sources, and use that to judge how much a payment should be affected fortnight to fortnight. And the High Court was looking at, okay, there was this issue, and how do we now, a couple of years later, fix that issue and decide how to fairly raise debts for people who might have some money owing to Centrelink.
Okay, interesting. So we are going to talk about debts and how it all works in a bit more detail. So what does the law say about Centrelink debts in general?
So the way that the law works with a Centrelink debt is it first looks at if a person received an entitlement, which is kind of what the law calls a Centrelink payment, that they maybe weren't entitled to. So it doesn't necessarily look at how that happened. It just looks at, did someone get a payment that they weren't eligible for? If the answer to that is yes, there is a debt.
Okay. And so how do people end up with Centrelink debts?
Lots of different reasons. It just could be that they've given information and it wasn't updated. So there's a lot of information that Centrelink needs when they're deciding how to issue a payment to a person. So a person might have missed a week of reporting their income from their job to Centrelink, or they might not have realised they had to tell Centrelink about their partner's income or changes to their studying. So if they're at uni and they might drop down to go part-time, those are things you've got to let Centrelink know because it can change your payment. And if you don't let them know, there could be a debt.
Yeah, and so is that because if you don't let them know the right information, they might pay you too much money, so an overpayment?
Yes, exactly.
Right, and then that's what leads to a debt.
Yes.
Okay. So what can Centrelink do if they think someone does owe them money?
Generally, what they'll do in the first instance is they'll write to the person and say, we believe that you may have been overpaid, and they will ask you to provide some information. So that could be if you are studying and you study loads change, they might ask you to provide some records about what you're enrolled in at TAFE or uni. They might ask you to provide some pay slips so they can check how much money you're making from working at a job. And then once they've got that information, they look at how much they did pay you and whether this new information means that that was either too much or possibly too little. And then if it was too much, they'll say, hey, here's a letter with your debt that you owe us, and here are the options for paying us.
Okay. So what about time limits? Is it just for debts over the last little while, or is it like how far back can Centrelink go in chasing debts?
Really difficultly for a lot of people, there is no time limit. So Centrelink can raise a debt in relation to a payment without a time limit. So a lot of other what we call jurisdictions have a 6-year limit. That doesn't apply to Centrelink. So it could be really old bits of information that they might be asking you about because there's no time limit.
Oh, that's really rough. So someone could, for example, get a letter from Centrelink saying you owe us a debt from like 20 years ago, and then asking you to prove that you don't owe them that money. And you've got to try and come up with some evidence. And it'd be so hard because you may not have records going back that far.
And that's one of the really big issues in that High Court case we were talking about is some of these debts are really old and no one keeps records that long.
That's really tricky. If Centrelink thinks you kind of did it on purpose and, you got some money maybe you weren't entitled to because you deliberately gave them the wrong information or they think you did, what can they do then?
So the consequences for that can be quite serious. Centrelink have their own fraud investigation team. So if they think that someone has repeatedly and deliberately sort of tried to fudge their records to get more payments than they should have received, they might refer that to their internal investigation team. And then if they think there's enough information, they can actually say to the Commonwealth Director of Public Prosecutions, we think this person has actually committed an offence because if you obtain a Centrelink benefit by deception or by, providing incorrect information, that can be an offence and they might look at charging you.
So that would then be a criminal matter that goes to maybe a local court or...
Yes, absolutely. It can end up in the courts with some pretty serious consequences.
Okay. So if Centrelink says you owe them money and you really don't agree, what are your options?
So there's a couple of options available to you. The first thing that you might do if you get a letter saying, hey, you owe us this debt, is asking Centrelink for what's called a debt explanation. And that's saying to Centrelink, hey, I'm not really sure why you think I owe this debt. Can you provide me more information about what you think has happened? And that will generally tell a person, because we didn't get your partner's information, or it's because we didn't know that you had this extra asset like a house that you weren't living in. And if that all comes back and you still go, no, that's not right, like I shouldn't have this debt, or okay, maybe even if I should have had this debt, I just am not in a position to pay it and I can't afford to pay it, you can ask Centrelink to relook at that decision internally. And they call that an authorised review. We shorthand it to ARROW, so you might hear ARO or ARROW floating around, but that means internally asking Centrelink, a different person there, can you look at this debt and make sure it's correct?
Okay. And so if that internal review comes back and says, yep, you do owe the debt and you still don't agree, what happens then?
So then the next option is to go to the Administrative Review Tribunal, or the ART, which is completely separate to Centrelink. It's an independent decision-making body. It's not as formal as a court, but it is a legal proceeding, and they have a specialist social security division there, and you can ask that tribunal to look at your decision and make sure it's correct that you owe the debt, and if there are any circumstances that mean that you shouldn't have to repay the debt.
Okay. So what sort of circumstances would mean you wouldn't have to repay the debt?
So there's generally two that come up and that are most common for people. So the first is, in legislation, it's called sole admin error. And that basically means that the debt arose because Centrelink made a mistake and you didn't know about that mistake, and essentially it wasn't your fault and it was entirely on Centrelink. It's very hard to get that one because you has to be entirely on Centrelink and you had to have no way really of saying, hey, Centrelink, I think you've made a mistake. The other option is what we call special circumstance, and that looks at, okay, there was a debt and that person didn't knowingly or sort of like deliberately try to sort of mislead Centrelink, and now they're in some pretty hard circumstances that would mean that it's not fair to raise that debt.
Not fair to ask them to pay it back. If the tribunal does agree that it's unfair to pay it back, they just make a decision saying the person doesn't have to? What sort of decision can they make?
Yeah, so they can make any kind of decision that Centrelink could have made. So they can say, I'm going to make part of this you don't have to pay back, or all of it you don't have to pay back, or you do have to pay it back. So they have a range of options there.
Okay. So what about if either way, either through Centrelink or the tribunal, the decision is that you do have to pay the money back, but you don't have enough money? What happens then?
So it's really important if anyone gets a letter from Centrelink saying that they owe a debt, that they engage with that letter. It's not a good one to sort of put at the bottom of the list and ignore. So you can either work with Centrelink and say, okay, can I go into a payment plan? And you work out a certain amount, by fortnight that you give back to Centrelink. If you're on a Centrelink payment, they just make that deduction from the payment that they give you each fortnight. Otherwise, if you don't engage with Centrelink, they have some pretty big powers, and they might even put you on their own payment plan, which could be a bit unaffordable for you. So it's really important that you say, okay, I know that there's this debt there. I will repay it back in these installment amounts because that's what I can afford.
What about if you don't have a Centrelink payment? How else can they take your money or get your money back?
So one of the things that can be really common is they issue what's called a garnishee notice. And what that means is they will take some money that might be otherwise yours. So often they can garnish people's tax returns and say, hey, you owe us this debt. You're going to get this money from the tax department. We'll just, forward that to us straight away to pay your debt. And that can be really scary for a lot of people because people think, oh my God, they're going to take my bank account. They do need to leave a minimum amount so you won't be with zero, but they will only do that if you're not on a payment plan.
Right.
Engaging in a reasonable payment plan. So that's why getting on that payment plan is really important because it stops those more drastic measures.
Okay, yeah. So as long as you're talking to them, they're not going to get your tax return straight from the tax office or start to take money out of your bank account. So, Dom, there were some changes to the law in December 2025, just 4 months ago. What were those changes and how do they relate to the court case we were talking to earlier?
Yes, so there were some changes and there were 3, I guess, really big ones that came out of it that are connected to the debts that we've been talking about and the court case. The first one is it validated income apportionment, which sounds very technical, but essentially what it means is things that were done because it was income apportionment, which was unlawful, are now just valid. That just says, like, okay, it was wrong, but it happened and we're just going to validate that.
And we will talk a bit more about what income apportionment is later on. You're saying that something that wasn't lawful before, they've now just changed the law to say, oh, by the way, we've just made that lawful, even if it happened in the past.
Yes, that's what the effect of these new laws is. And what it means for people is if you had a debt that was raised using income apportionment, that's now a valid debt and Centrelink can ask you to repay it.
Okay, what are the other changes?
The second one was the law recognises income apportionment happened and it was unlawful, so it has created a resolution scheme to provide people with a payment as recognition they went through this unlawful debt process.
Okay. And what was the third change?
The third change was it has improved the considerations that Centrelink might look at when it's waiving a debt and essentially made it a lot more accessible for people who are in really difficult circumstances to access a debt waiver. So we're very excited about those changes.
Oh, great. Okay, I'm looking forward to talking to you more about that. Let's start with income apportionment though. A lot of us have heard of robo-debt. Is it the same thing or what's the difference between robo-debt and income apportionment?
It's not quite the same thing. It is very easy to get the two confused and they happened at the same time and a lot of people unfortunately were affected by both. What actually income apportionment means is when you get most Centrelink payments, you've got to report to Centrelink if you have a job and how much you're earning. So most people would log in on a fortnight and say, I worked this many hours and I earned this much money. Everyone's got to do it. And for the most part, Australians are actually really good at reporting their income and telling Centrelink how much they earn. Apportionment just means essentially the maths method that was used to say how much should all of this money this person is earning affect their Centrelink payment. And Apportionment just meant Centrelink applied that in quite a smooth way across a number of fortnights, whereas actually it needed to be a lot more precise, and they needed to say that income that was earned in that Centrelink fortnight is only looked at in that Centrelink fortnight, not smoothed across a number of fortnights to get a sort of same daily number.
Mm. So how many people would have debts that are affected by this this method that was unlawful at the time, let's say?
Quite a number, because essentially it's applied to any Centrelink payment that was income affected. And that really means any Centrelink payment where if you earned any money, it might have affected how much you got from Centrelink. So it happened between 2003 and December 2020. So we think it's sort of somewhere possibly in the 2 million people may have had an income affected debt.
Wow. So that's over a 17-year period we're looking at. And that's a lot of people, a lot of people. Wow. Okay.
The most likely ones are youth allowance, job seeker, or like DSP, parenting payment. So any of those ones where you had a requirement to say to Centrelink, this is how much I'm earning, could have been affected by income apportionment.
So if that decision about how they've calculated the debt was wrong, will they end up paying people back, or how does it work?
So the effect of the new change is it validates the fact that income apportionment was used. And a lot of these debts people have paid back to Centrelink. There's only a really small number from that period that are still outstanding. But the effect of validation means it happened, but we're now going to say it's lawful. So you can't just say, I'm not going to pay this debt because you use this unlawful method anymore. Like that's no longer available. If you still think, if income apportionment was used, I still don't agree that I owe this debt because I think I reported correctly, or I had these other factors that mean that you have calculated it wrong, you still can ask Centrelink to review that debt. And what these new changes implement is quite a sort of strict 3-step process. And the first one is Centrelink will ask you for information, if you have it, about that time and when you earned your income. So they might ask you, did you keep any timesheets from when you worked? Did your employer keep any timesheets from when you worked? So we can see when you earned your income, so we can put that in the right fortnight. A lot of people don't have those records because they're quite old and you don't really keep timesheets. You might keep your pay slips, but you might not keep your timesheet. In that case, you would move to the next approach, and that would look at if you have a date that a person was paid and can see that this person received their income on this date and put that in the right fortnight and make sure that their Centrelink payment can be adjusted based on that. And that could bring your debt up or down, or it could sort of remain pretty much the same. And then finally, if they don't have any evidence of your payroll period like pay slips, there's no timesheets, they can look at things like bank statements to be like, when did your pay hit your bank account and what's the right fortnight to put that in?
Right. That's really hard because often it's when you get paid that most impacts how you budget week to week, isn't it?
Yeah, it's really, I guess, one of those weird things of the law where it has a sort of maybe a different meaning to lawyers. And so a lot of people will go, when did you earn this income? People will be like, the day it hit my bank account. That's when I got it.
Yeah.
What actually we're looking at is you might have worked and earned your income earlier and then you received it from your job later, and they could have been in different Centrelink fortnights because they don't often overlap.
Yeah, exactly. So you mentioned the government has introduced this income apportionment resolution scheme. What is it?
It is essentially just a recognition payment to say you went through this unlawful process, and the payments that you can receive under that range from $200. So if your debt was less than $200, you'll get a payment the same as your debt. If it's between $200 but less than $2,000, you will get a payment of $200. If your debt is between $2,000 and $5,000, you'll get a $400 payment. And if it was more than $5,000, you'll get a $600 payment. So they're the 3 categories of payment, essentially.
Okay. When does this scheme start?
So the scheme started from the 30th of January 2026. That's when people could go to Centrelink and say, I think I am eligible for this scheme. And what is really important is it is only open for 12 months. So you have to have applied for the scheme by the 29th of January 2027, or you'll have to ask for a special exemption to get an extra 12 months to make your application.
Okay. And so who did you say is eligible for this scheme?
Anyone that had an income apportionment affected debt is eligible, and they might be eligible for more than one payment. So some people might have had more than one debt that is affected by this issue, and they can get a recognition payment for each of those debts. It's really hard to sort of say if a person will or won't be eligible. The problem, as we've sort of spoken about, was quite big. It ran for 17 years.
Yeah.
So there's probably a really good chance that anyone that was getting a Centrelink payment where they had to report their income to Centrelink could be affected by this issue. The only way to check, apply for the scheme and see if they accept you.
Yeah, right. So if you've got a debt that's come up any time in that 17-year period, there's a pretty good chance you might be eligible. So the payments seem kind of small, and I'm trying to get my head around this. So you get a payment between $200 and $600, right?
Yes.
But the debts could be a lot more than that, right?
Yes. Some people's Centrelink debts, because of the way they've been calculated, can be in the thousands of dollars. Unfortunately, $600 is the max that you will get in respect of a debt. And the other important thing is if your debt has been waived, so Centrelink says, yep, you have a debt, but you don't have to pay part of it, they will minus that from the debt value, which might affect how much of a payment you'll get. So if your debt was, for example, $5,400, you could have got a $600 payment. But if you'd already appealed it and they said, actually, we note that you're in some really hard financial circumstances, so we'll bring that debt down to, say, $2,000, you'll actually then get a $400 payment.
Just say you do have a $5,000 debt you're still paying off and you end up getting an offer under this scheme and you accept it. What happens? Do you still have a debt? You still have to pay the rest?
Yes, you still have a debt and you still have to pay off that debt. When you accept your resolution payment, you can either say, can you put this towards the debt that I'm currently paying off? Or no, I would like to receive that as a payment.
Okay.
But yes, you still have to pay that debt off. It does not change the fact that you owe Centrelink money.
Okay. So how do you apply for this? You mentioned something about asking Centrelink, but what's the actual process?
Yes. So the process does require a person to be quite active in looking into whether they can get a resolution payment. Just because you haven't received a Centrelink letter about the resolution scheme does not mean that you shouldn't apply and check if you have had a debt. So Centrelink have started to send out letters to people who they think could be affected by this who currently have debts with Centrelink. So they're getting a letter saying, do you want to make an application? And you can either apply by phone or you can go into your MyGov and into your My Debt section, and there is an application process there. But they won't necessarily send a letter to everyone that's potentially eligible.
Okay, so you've got to be really proactive, and people may not even know about this.
No, so people may not know if you ever received a Centrelink payment and you've had a debt, it's worth looking to applying for this scheme.
Yeah.
It's free to apply for. So it's open to people to check their eligibility.
Yeah, it's nothing to lose. So the process of checking your eligibility is actually applying.
Yes.
Yeah. And do you have to know a lot about your debts when you make the application?
No, so Centrelink does all of the checking. So if you're going in, say, through your MyGov account, there will be a section there that says My Debts, and it should have the debts there that are potentially eligible. The only time that you probably need to know more about your debt is if you do apply and you get rejected from the scheme and Centrelink are like, no, you didn't have the right kind of debt, you probably need a bit more information if you want to challenge that decision.
Wow, I just think it's actually so confusing. You're getting paid some money because the way they raised a debt was unlawful that can potentially reduce the debt, but you still have to pay that debt.
It is a really unusual situation, but there are places like legal aid and community legal centres that can talk them through this and provide them information. But yeah, it's a pretty unusual circumstance we're all in.
Yeah. And you mentioned that deadline. What was it again?
The deadline to apply is the 29th of January 2027, so it's open for 12 months.
Okay, so we're in April now. So if people are hearing this, they need to be really on it with their clients and just make sure they're asking about debts and encouraging clients to interact with Centrelink and make these applications. So did you say if somebody's already paid off their debt, they're not eligible, or are they still eligible to apply?
Nope, they are absolutely still eligible. It doesn't matter if you paid off your debt. And one other thing as well is if you are repaying your debt each fortnight, giving a certain amount to Centrelink, when they look at how much you're eligible for the resolution scheme, they don't look at how much you've paid off. It's how much they originally asked you to pay.
So yeah, if it's originally a $5,000 debt, you can still get the $600.
Yes.
Yeah. Okay. And what's the process if you don't like the offer you get, or you don't get an offer and you think you should? What's the process then?
There's a process to review. It's a little bit different to how Centrelink usually look at their review decisions. So the first thing that happens after you make an application is you will get a notice of offer if you're eligible. So it will be a letter saying you've applied, we think these debts are eligible, and this is how much we think your resolution payment should be based on those debts. And you have 56 days to say, yes, I accept that, or no, I think it's incorrect. If you want to accept it, you've got to then lodge your acceptance of that offer. So you can do that online, you can do it in a local Centrelink office. And if you accept that offer, you will also be asked to agree to waive any rights to pursue the Commonwealth. So that's like the Australian Commonwealth.
The government, yep.
Yeah, the government in relation to this unlawful practice. So it doesn't affect your ability to seek a review of your debt, at the tribunal or internally, but it does mean anything like class actions or those types of legal proceedings against the government in relation to income apportionment, you waive your right there by accepting this resolution scheme payment.
Mm. So tell us about what happens if you're not happy with a decision that gets made. Like, so you make the application for this scheme, you get a response, and you're not happy with it.
If you're not happy with it, you can ask Centrelink to look at it again. We call that asking for a review. And you have 56 days to do that. So from the date that you get that letter saying we're either not going to give you this payment or you're only going to get this amount of payment, it's 56 days to say, hey, I think that's wrong and I'd like you to look at this again. If for whatever reason it's really hard for you to respond in that 56 days, like you need more time, what you can do is ask for an extension of time and say, I need more time to look at this and to respond. And Centrelink can give you an extension of time. If they don't give you an extension of time, you can also actually ask for them to review that decision that has a shorter time limit. That is only 28 days.
Okay. If you want an extension of time, do you have to ask like before the end of the 56 days?
Yes, you've got to ask before the 56 days are up.
Okay. They're still really wanting you to be very engaged in the
Very
process.
engaged in the process. And if they say no and you apply for a review and they say, look, we still think it's a no, your review right there stops.
So basically it's all dealt with in-house at Centrelink.
Yeah.
Yeah. So can you give us a case example just to illustrate how this might work?
Absolutely. So one of the most common types of payments that we know were affected were people who were on youth allowance. So that might have been people studying at TAFE or at uni. They might have had a casual job that they worked in the holidays and sometimes on weekends. And at the time that they were getting their Centrelink payment, so this could have been, 10, 15 years ago, they would report to Centrelink each week saying, I earned a couple $100 this week and I earned a couple $100 this week. And Centrelink might have made their payments a little bit higher, a little bit lower, depending on how much they were being told this person worked. We now know when they were making those adjustments, they were using this unlawful method of income apportionment in a lot of cases. And a person might have then got a letter a couple of years later saying, we looked back at your, 2014, 2015 Centrelink payments and we think that you were overpaid, $1,500 and that's a debt. You might have gone, okay, I've got to pay this debt back to Centrelink, and you might have paid it all in once or in a payment plan over a couple of years. And now you might sort of see on the news or hear this podcast going, hey, like I had a Centrelink debt and I wonder if it was affected. You can contact Centrelink and say, I paid back a debt to Centrelink. I had to report income. Can I check if I am eligible for this resolution scheme payment? And Centrelink will do that for you. They will do the checking of whether you are eligible, and you'll get this letter saying, actually, yeah, you were on an income affected payment and we did use income apportionment. You've paid off your debt, so there's no need to do anything further there. But because you had a $1,500 debt, that means that you will get a resolution scheme payment of $200. Can you let us know within 56 days if you want to accept that?
Okay, that makes it nice and clear. Thank you. You've given us a bit more context about how Centrelink operates now when it comes to debts and now these changes in terms of income apportionment and the scheme. I heard something about debts being paused for years and maybe they're going to start being pursued again. Can you just give us an idea of what that's all about?
Yes, so that is true. Because there has been this process of going through legal proceedings since December 2020 and during the beginning of this year, Centrelink didn't actively take steps to recover debts that possibly were affected by income apportionment. So a lot of people may have these debts, but Centrelink hasn't really been communicating with them other than to say it's paused. Now that the act has been changed, Centrelink are like, we're confident now we can go to people and say, you have this debt and you need to repay us. So the other thing that might be a bit confusing to people is they'll get this letter saying, hey, we're going to start recommencing debt recovery from you for a debt that they haven't thought about, since before 2020. So it's important if they do get that letter to not ignore it and go, hang on a second, do I have to engage with this? Do I need to get on a payment plan? And then also possibly look at if they want to go for the resolution scheme.
Right. So the two things could happen around the same time. They might get a letter from Centrelink saying, hey, we're going to chase you for this debt now. They might also get a letter from Centrelink saying, hey, you might be eligible for this resolution scheme, and they can potentially apply for a little payment towards that debt.
Yeah, it's going to be a very weird situation of can you please start repaying us some money, but also here is some money. But it's the world that we're in, and I guess going to legal services or being proactive about it is the most important thing for people at the moment.
That is a very interesting set of circumstances, and hopefully people are understanding the importance of actually being proactive about any debts that they have. To try and end on a positive note, let's talk about the positive changes to the Social Security law that happened in December 2025. So there were some changes around small debts. Can you tell me a bit about that?
Yes. So a small debt is essentially a debt that Centrelink says that's too small for us to recover. We won't seek to recover that from a person. And this had a bit of a delayed start. So it took effect from the 20th of March, 2026. But what it means now is that if someone's social security debt or their Centrelink debt is less than $250, that debt will be waived.
Okay, so that is that automatic, or does a person have to ask them to consider not pursuing that small debt?
It should be an automated process.
Okay, and what are the other positive changes?
So the other positive change is when Centrelink is looking at if there are special circumstances to waive a debt because someone's not able to pay it back.
Hmm.
It used to be that you could not have knowingly made a false statement or representation or not complied with the Social Security Act. So a lot of the time, what would knock people out at that stage is if they had not reported their income or told Centrelink about a change of income or a change of address that they were now living with someone else or they were in a member of a couple situation and they didn't tell Centrelink about that, that often meant that they couldn't get this special circumstance waiver because they had knowingly made a false statement or misrepresentation. And that was a really hard situation. A lot of the time, a person was in a situation that meant it was really difficult or possibly even dangerous for them to comply with that obligation. So we would see a lot of people that, might have been in a member of a couple situation and there could have been some coercive control or domestic violence happening in that relationship. And because of that violence or coercive control, they had either been told, do not tell Centrelink that we're in a relationship. And the person was essentially too scared to tell Centrelink, even though they knew that Centrelink needed to know that they were a member of a couple.
So the person receiving the Centrelink payment was the one who was afraid, and their partner might have been the one pushing them not to tell Centrelink, and that might be a DV situation that you're talking about.
Yes, and unfortunately that person who was receiving the payment is the one that gets the debt, even though they hadn't done really anything wrong. They were just acting out of fear. The law now is a lot more responsive to people in those situations, and the person may have knowingly provided information that was incorrect or a misrepresentation, but doing so was justified in the circumstances. So one of the ways it could play out is someone might have been receiving rent assistance and they might have lost their accommodation and they didn't, immediately have other accommodation available to them. So they might have been couch surfing, sleeping in their car, and it takes them a couple of weeks to find somewhere new to live. In that time, when they stopped paying rent, they needed to have told Centrelink that they were no longer paying rent. But things are really expensive. It's really hard to find accommodation. And a person who doesn't have stable accommodation might have been really afraid to have their payments reduced and lose their rent assistance because they wouldn't have been able to afford a new place to live. And that could have impacted on whether they reported to Centrelink that they were no longer paying rent because they just were like, needed every part of that payment to help them get through week to week. Now, Centrelink can look at those circumstances and say, yes, you should have told us that you stopped paying rent, but we appreciate in all of these other circumstances, it may have been justified for you to not tell us that, and we can waive the debt so long as you still meet special circumstances. With these new changes, what Centrelink can now look at is whether if you had knowingly provided incorrect information, but it was justified in the circumstances for you to have done so, and there are, factors like family domestic violence, your financial circumstances, disability, different reasons that they can look at to go, that was justified in the circumstances. They can also look at if someone else had provided incorrect information that affected your payment. So the most common that we see in our line of work is if a person is in a member of a couple and the other member of a couple had provided incorrect information to Centrelink. That used to be a barrier to you getting the waiver. Now, Centrelink says we can also look at information that another person provided. And if you didn't know about that false or incorrect information being provided, you might still be eligible for a waiver. Or even if you did know that other person was providing incorrect information, it was justified in the circumstances for you not to correct that. And again, domestic violence is a really common example we see here of a person sort of knowing that their partner might be providing incorrect information and being afraid because of factors of violence and coercive control about correcting Centrelink.
Yeah, okay. And that incorrect information, the kind of incorrect information that a partner might be giving in that situation, is that something like potentially their income, their assets?
Potentially their income, even declaring that they
Mm,
are a partner or that they're living together. So it can be a range of things, but anything that could have affected how much
yeah.
payment that you would have received.
Okay, well that's a good development. It sounds like that there's more scope for people to potentially have their debts waived now, and that the conditions are less harsh. Um, and that's really especially important for our vulnerable clients who are experiencing things like domestic violence or homelessness, and it gives them options and maybe a better pathway to having their debt waived.
Yeah, absolutely. It is really a positive step forward that now, as well as showing the difficulties a person presently might be in to justify waiving the debt, they are also going to look at what was happening in that person's life at the time that they provided Centrelink with information that wasn't complete, and looking at, okay, there are a lot of things going on in people's lives. There might be so many different reasons why you might be really scared to have your Centrelink payment reduced.
And so does this apply just to new debts since the law changed in December, or is it also to debts that came up earlier on?
It applies to both old and new debts.
All right. So to wrap up now, we've got our audience of community workers. What is your key message for our listeners?
I would have 3 key takeaways if I'm allowed 3.
You're allowed 3. Yes.
The first would be that there are going to be people possibly getting letters from Centrelink about debts that they may not have recalled they had because they have been on pause for quite a number of years, and to not ignore those debt letters. You need to engage with it either by going on a payment plan or seeking review. So don't ignore debt letters, even if you can't remember what the debt was for. It's a
Mhm.
really old debt. The second is there's a resolution scheme available to people, and it's really important that people engage with that scheme if they think they are affected. There won't necessarily be a prompt from Centrelink for them to engage with it, so people need to be proactive about going, I want to check if I'm eligible because I could receive a payment as a result of this.
Mhm. Yep.
And the third is the way that Centrelink is looking at debts is changing, and possibly that is going to be a more positive world in terms of debt waivers, and there might be more opportunities for people to have their debt waived where they previously wouldn't have been able to.
Well, that is great. That's a good note to end on. So if people want some more information about all this, where can they get that information?
So they can come to Legal Aid. Legal Aid provides Social Security advice. We provide Social Security debt advice, and they can contact their local Legal Aid office or Law Access. We also have a number of great community legal centres, and they also often provide Social Security and debt advice. We've got fact sheets available on this, and they're a really helpful resource that just puts this all in writing and just lets people know key dates about when they need to apply for the resolution scheme, for example.
Okay, that's great. And we are going to actually link to those fact sheets in the notes for this podcast episode so that anyone who's listening can click through and have a look at them. Awesome. Thank you so much, Dom.
Thank you.
That's all for this episode. Thanks for tuning in, and special thanks to Dom for sharing her expertise with us. As always, you can check the description for all the links and resources mentioned in this episode. Law for Community Workers is produced by the Community Legal Education team at Legal Aid New South Wales. If you have any feedback or want to collaborate on a podcast, email us at cle@legalaid.nsw.gov.au. If you haven't already, make sure you sign up to our Law for Community Workers alerts to receive updates about resources, webinars, workshops, and more. Remember, everyone's situation is different. What we've discussed in this podcast is information only and cannot be relied on as legal advice. It's based on the laws in New South Wales and is correct at the time of broadcasting but may change. If you or someone you know needs legal help about a particular situation, start with our team at Law Access New South Wales on 1300 888 529 or via web chat at legalaid.nsw.gov.au. Catch you next time.